Hi, I'm Sheridan Clemens. I'm a VP of Data Privacy, and I am here with three fabulous individuals that I'm super excited to introduce. I've got our CEO, Justin Antonopoulos. I've got Michael Hahn from the IAB, and Gary Kibble from Davis and Gilbert. All three of them wonderful backgrounds and experts in this area. Excited to talk to you about how the Sephora decision changed our expanding scope of sale. And I'm going to just drive right into it. Gary, do you want to introduce yourself and maybe give us a little bit of an understanding about how this is affecting the legal perspective?
Sure. So, hi, nice to see everyone or hear everyone. I'm Gary Kibble, a partner at Davis and Gilbert in New York, and certainly practicing a lot in the areas of ad tech and privacy. And the Sephora decision is certainly one of the hottest topics out there. Justin, do you want me to jump right into it, or we can each introduce ourselves first?
Yeah, how about quick intros for both you and Gary? Give a moment, if you wouldn't mind, about your background before we turn it over to Michael.
Sure. So I've been at Davis and Gilbert for 20 plus years, and pretty much have been working in the ad tech and media and privacy space all throughout. So back when it was sort of a blip on the radar, and now it's the primary topic that everybody wants to talk about. And I spend most of my time working with everyone within the ecosystem, whether they be ad tech companies, publishers, brands directly, and media buying agencies. And certainly there are a ton of issues going on right now for every single participant in the ecosystem.
I'm Michael Hahn. I'm the Executive Vice President, General Counsel of the IAB and IAB Tech Lab. For those who don't know, the IAB is a trade association that represents the big tent of the digital advertising industry. Our members include publishers, advertisers, agencies, and ad technology companies. I like to think our differentiator is that we don't represent just a segment of the industry, but rather the entire industry. And so it's the place where we come together to try to solve big, hard, practical problems. And there's nothing more challenging than the complicated state privacy compliance landscape right now, which is one of the things that we pull our members together to work on.
Michael, thank you. And I'm Justin Antonopoulos. I'm the CEO of WireWheel. I'm really delighted to be here with you both and with Sheridan here today as our moderator. And I already can see from the attendees just a wonderful group of friends and colleagues from both privacy and marketing industries across the country. And I'm delighted to see everybody here today. I know this is virtual, but if we really would love to interact with folks. And so if you do have questions, please post them to the Q&A, and Michael, Gary, and I will jump in and try to actually address them. WireWheel has been providing technology and software solutions for privacy compliance for now 6+ years. And we've been in the consent and preference space for years. But I think there's been quite a sea change that Michael and Gary and I have seen for, certainly in the last 2, 3, 4 years on these issues. And the subject of this webinar is on one very small but very, very important part of this. And we focused on this for a reason. And the reason is, in my experience with marketing teams and marketing operations teams and brands across the board, is that marketing teams and legal teams are very careful about trying to make sure they're making a decision before they sell their customer data. That's a very important thing to many, many marketing teams. And if you ask marketing folks, are you selling your customer data? They know the answer to that. And usually the answer is no, I'm not selling my customer data. I don't sell my IP addresses. I don't sell my customer actual IDs. And if they do, there's been a process to it where they've decided it. One of the things that was critical, and I know Gary's going to cover this, is that California is expanding what
Sorry, Justin, I
Can
think
you all
we,
hear me again?
Yeah.
yep, we can hear you now.
By the way, that's what happens when you have a pair of AirPods in your pocket and they open. So the expanding scale of what is a sale of data is really important. It's very important to marketing teams. It's very important to brands. You should know when you're doing something that is a sale of data. And that's what we're going to start our conversation on. I think when companies found out that use of a pixel that shares data directly between your website and a social media platform is a sale of data to somebody in California from a regulatory perspective, it caught a lot of our attention. And we're going to talk about it from the legal, from the IAB's perspective and from the technology perspective in terms of what you need to know to have this conversation inside your companies. So I'm looking forward to the discussion, and Sheridan, I'll turn it back over to you to kick us off with Gary.
Yeah, thanks, Justin. Gary, so I know this Sephora settlement has really raised a lot of questions, and from a legal perspective, I think a lot of people are searching for meaning and understanding. Can you give us a perspective on what you've taken away from it and how you're thinking about it?
Sure, definitely. And firstly, apologies for the weird lighting, the hostage video lighting here. I'm actually not in my office despite my virtual background. I'm at a conference in Orlando. And everyone where I am right now is talking about the Sephora action because it really is an important action, not just on its merits, but also it's the first one, the first publicly announced enforcement action out of California. Now, there have been many enforcement actions by the California AG just directly with companies that have not been public. And there was a summary of those on the California AG's website. So you can get a sense of the issues that they have been focused on. I think there's about 30 summaries that have been anonymized on the California AG's website. And some of them have similar themes to what we saw in the Sephora action. So looking at the Sephora one specifically, so CCPA has been around since January 1 of 2020. It's now 2.5 years later, and this is the first one we've seen publicly. Keep in mind that CCPA still has a 30-day cure period. Now, I don't have the backstory about what happened here, but there was a 30-day cure period. So the way that the California AG currently operates is they would send a notice to a company identifying all the shortcomings with respect to compliance, and they have 30 days to cure. What happened here is that the California AG, after we assumed that process had played out, prepared a complaint that was to be filed and then settled with Sephora. Now, the complaint focused on two major issues, one of which I will say is a bit surprising and one I would say was not too surprising. But the latter one first was about what Justin was talking about when pixels from a third-party provider are on a publisher's site. Is that a sale of personal information under the CCPA, or are you in a service provider relationship? The second part of this settlement was about compliance with GPC signals, global privacy control signals that are automatically sent by a user's browser to a publisher's site. So looking at the first part about the third-party provider pixels that were on Sephora's website, and maybe we can put up slides with a couple of those quotes there from the settlement, which are helpful. Now, there were a number of things that the AG said in the complaint. Firstly, they were talking about the fact that there could be sensitive data that's being collected. And they said here, if companies make consumer personal information available to third parties and receive a benefit from the arrangement, such as in the form of ads targeting specific consumers, they are deemed to be selling consumer personal information under the law. Now, that middle part there, receive a benefit from the arrangement, that, as many of you know, is because the definition of sale under CCPA is not just selling personal information for money. It's selling it for monetary or other valuable consideration. So if you have a pixel from a third-party provider on your website, and for free, you get great analytics, and in exchange, the provider can use the data generated on the publisher's site for their own benefit, then that may be a sale of personal information. And if you are selling personal information, you need to give consumers the ability to opt out. Now, there were a number of things going on which come up in the complaint here. They talked about Sephora's privacy policy, where it said that they do work with third parties to do targeted ads, but in their California section said they do not sell personal information. So there's a disconnect in the privacy policy. And then when the California AG looked at the website and saw all the pixels there, they assumed that data was being sold and that there should be an opt-out, but there was no opt-out method at the bottom of the website. If you are deemed to be selling personal information, you must have a link on the homepage of the website with these 6 exact words: do not sell my personal information. There is no other option currently for having that opt-out option on the website. So that wasn't there. Now, there are 2 avenues here. You can either deem to be selling personal information to a third party, or you could be in a service provider relationship with that pixel provider. If you're in a service provider relationship, there needs to be a written contract with that provider that restricts the way that they're going to use the personal information collected from the site. So when the AG asked Sephora if they were selling personal information, again, I don't know the backstory. If they said no, it's a service provider relationship, then the AG likely said, show me the service provider agreements. And those couldn't be provided either. So there's got to be one of 2 avenues here. Either you're working with them as a service provider and you have a contract proving that, or it's a third party to whom you're selling personal information and you have to give consumers the ability to opt out. They couldn't satisfy either one of those prongs. Sheridan, let's go to the next slide. I think there's another good quote there. Yes, it says both the trade of personal information for analytics and the trade of personal information for an advertising option constituted sales under the CCPA. Now, there were other things that maybe spurred the AG for taking action here. They talked about the fact that there could be sensitive data involved here. Sephora was using a common practice of targeting people for shopping cart abandonment. When they put something into their shopping cart, they don't complete the transaction and they leave the website. Then you want to send them an email saying, hey, you left stuff in your basket. Are you interested? Or to serve them targeted ads on other platforms based on what they might be purchasing. And at least in the complaint, they talked about that there could be things such as prenatal care and other pregnancy care in the shopping cart. So there could be sensitive information that's in the shopping cart. The California AG also threw into the complaint one of the words that we in the advertising industry hate. They threw in the word surveillance. Now, again, this is a buzzword amongst regulators, surveillance advertising, which is not something defined in the law anywhere. That's not something that's, impermissible under any specific law, but it's a buzzword that regulators are using to denigrate ad-supported business models and data-driven business models. So that word surveillance is really just, an inflammatory buzzword that they threw in there, but it shows how the Attorney General is concerned about these issues. All right, we could talk a lot more about that first part, about the third-party pixels, and I definitely welcome your questions on these issues. Let's talk about the second part of the settlement, about the global privacy control. So I mentioned the first part to many of us in the industry about the pixels was not too surprising. But with global privacy control, there was some surprise. Now, under California law, they refer to opt-out preference signals. And those are opt-out signals that are automatically sent by a browser from the user's browser to the publisher's site. As many of us know, in the CCPA, in the law itself, this is never even mentioned. There is not a single mention of opt-out preference signals or global privacy controls. But it was introduced in the regulations to the CCPA, and it was introduced in a very simple way about honoring user-enabled preference controls. And many in the industry said, well, I don't know what it means to be user-enabled, especially if a browser sets it by default. So, and there was only about 1 or 2 sentences on this in CCPA. So many in the industry were not implementing compliance with GPC signals. CPRA, which takes effect on January 1st, the California Privacy Rights Act, does directly address opt-out preference signals in the law itself and at length in the regulations, which are in draft form. The second draft of the CPRA regulations was released a week ago. But it seems under CPRA, it's very clear that you have to honor global privacy controls and opt-out preference signals. However, the Sephora action made it clear that the California AG said, no, you need to be honoring GPC signals now, immediately. There's no waiting until CPRA takes effect. So what do we have as guidance? That makes it really challenging because the CCPA regulations really don't tell you anything about how to comply with GPC signals. In the draft CPRA regulations, there's about 2.5 pages of compliance with GPC signals. So what are businesses supposed to do right now? Well, the takeaway is certainly that the California AG thinks you must honor GPC signals immediately. In terms of how, maybe you could look at the CPRA draft regulations to see what it says there and use that as some guidance. With that, maybe I'll stop for a second and kick it back over to Justin and Michael, although I'm sure we're going to have a lot of questions on some of these things that I just raised.
Thank you, Gary. Appreciate it. Michael, just a quick question for you. You know, Sephora and the CPRA sets up some complicated legal arrangements and necessary signaling. How is the IAB thinking about supporting these issues?
So taking a step back, what I do at the IAB is I help lead our IAB Legal Affairs Council, which is composed of 350 industry lawyers who are focused on solving privacy problems. I also help as general counsel to the IAB Tech Lab in its working groups of product and engineering leaders who are also focused on solving some of the privacy challenge from a technology standpoint. So really there are two sets of things that we have been focused on trying to do to assist the industry with compliance. The first is on the IAB Tech Lab side. So one of the important things that you need to do under any privacy law, and is also required under CPRA and the regulations and implicitly in some of the other laws, is you need to communicate the consumer's privacy elections that are done in a manner compliant with state law to the other participants who receive the personal information in some fashion. And obviously, you know, what they need to do with the information is a little bit of a different story. But on the technology side, we set up what I like to think of as an elaborate form of plumbing for the industry. We are designing the schematic for the plumbing and telling everyone to build to this set of plumbing plans. So in the Legal Affairs Council, we come together and we say, what do we need to communicate to lawfully process a digital advertising transaction? And we come up with these list of things that would need to be communicated from publishers or advertisers to ad technology companies. We give this then to the engineers over at the Tech Lab and their working groups. And then they say, okay, we need to take these requirements and turn that into a technical specification. So we recently released what's called the IAB Tech Lab's Global Privacy Platform, which is encoded to handle state level signals. So if you think of, and we use some awfully big words, it is basically a concatenated string. Each section of the string has a different jurisdiction. And so if you have a consumer from Virginia, let's say, you would have a bunch of different slots. Did you provide notice pursuant to the provision that is applicable in Virginia's law? Did they opt out of sale? Did they opt out of targeted advertising? Did you either consent or opt out, depending on the state you're in, with respect to sensitive personal information? And that information would get passed from the publisher or advertiser down to the ad technology company, and they might send it to another ad technology company. So that's one thing that we're doing to support the state compliance. The second thing is, what are the rules that need to exist for companies when they send the signals using this plumbing and when they receive the signals? And that's where we've come up with this industry contract called the IAB Multi-State Provider Agreement, which the comment period closes this week. And really what this does is it creates a springing set of obligations that apply to all of the signatories. And they spring into the place in a manner that follows the personal information. So there are a number of requirements that are very difficult to figure out with just your own contracts alone. And we could talk a little more about this, but just at a high level, what we're doing is we are creating a common baseline set of privacy terms that can flow through the digital ad chain and also fills in gaps where you need contracts, but you don't have contracts. And if you spent the next 100 years trying to write contracts, you will not be able to scale with enough of them. Getting back to our main concept here, given the broad definition of sale that exists today as the regulators applied in the digital advertising context, which for all practical matters seems to apply to nearly every disclosure of personal information. And there are not always even contracts in place with respect to all of these disclosures of personal information that happen. We'll talk a little more about that as the day goes on, but generally that's what we're up to in trying to address these challenges.
Perfect. That sounds great. Michael, we do have one question for the IAB. How are you determining the jurisdiction of consumers to begin the consent stream?
So that is determined by the first party. So for example, we say in the draft multi-state provider agreement that you need to use commercially reasonable means to determine the jurisdiction of the consumer. So there's no perfect answer, as we all know in the industry, right? If you have a first party relationship and they're a logged in user, you've got their personal information. Most companies use IP address as a proxy for the location, but that's not perfect. I like to say that I think that is commercially reasonable because I haven't heard anyone say they've got a better answer than that. That being said, one of the things that we've provided for in our multi-state privacy agreement, by example, is what we call a program for what we define as the national consumer. So we have created a flexible approach which says you could determine the residency of the consumer through those commercially reasonable means, and then you can follow the rules that are state specific that we have reviewed and applied in the contract. But there are certain publishers and advertisers who may say, A, I can't determine the residency of the consumer, or B, I don't trust IP address. And so even though that's the prevailing way that it's done, I don't want to take that risk. Or C, I simply believe that all consumers in the United States who come to my site, to my app, should all be treated the same. And so I'm not going to do anything to determine the residency. So in any of those instances, we provide this option where you basically don't determine the residency, but you say, I'm going to assume, for purposes of this contract, that they're a resident of all 5 states whose privacy laws are going to be in effect. And in doing that, we have gone through the law and parsed through to determine what is the highest common denominator across all of the laws for the various issues. And so one way to comply, even though you don't know where they are, is to take the highest possible legal standard across those laws. So we make that an option as well.
Yeah, and I think taking that national approach may be a common approach for clients for a number of reasons. Firstly, with 5 states coming online in 2023, I think I did the math at one point. It's going to be greater than 20% of the U.S. population, maybe close to 25%. That's covered by these privacy laws. And as Michael said, the challenge of identifying where people are located. There's also the oddity of the definition of a consumer under each of the laws. For example, under Virginia law, it just says it's a resident of the Commonwealth of Virginia. For California, they do this weird thing of using the definition of consumer that comes from California's tax regulations. So that if somebody lives in Lake Tahoe for 4 months and San Francisco for 8 months, that's how they calculate, are they a California resident for tax purposes? So the CCPA borrowed that definition, which of course is not workable, because if that consumer is sitting in Lake Tahoe for 4 months and you're looking at their IP address, you have absolutely no idea that they are a California consumer. So there are a lot of challenges. It can't be perfect. We're also dealing with the restriction that California regulators don't want you to ask for too much additional personal information to verify somebody. You need to just do what's necessary in order to verify them. So just my personal opinion from a business point of view, I think a lot of people will go with the national approach, but you're not required to. There are only these 5 states we need to worry about next year.
I totally agree, Gary. It's a murky area. Thank you, Gary and Michael. Justin, do you want to talk about how we're thinking about the expansion of sale and CPRA from a technology perspective?
Yeah, sure. And that, first of all, those were great highlights of critical things to know from both you, Michael, and Gary. So maybe I'll start with 2 critical things. The first is, when we summarize what Gary covered on just Sephora, and Sephora is just the small leading edge, because it's essentially enforcing what California is saying was just under CCPA, right? Because that's the only thing in effect, interestingly. So there are 3 things that Gary highlighted. One, and I'm using non-legal, just being sort of shorthanded for our community here, Gary, if you don't mind bearing with me. If you have automated scripts, tags, or pixels that are going, directly to a third-party platform, you have to put a wrapper around it. You have to be able to know that it's not going to go automatically, and you have to have a way to control them. So as Sheridan, obviously, that's one technology area that WireWheel has been thinking about and bringing to the table. The second is, if you have that marketing going on, as Gary highlighted, you need a place that a human being can come and easily opt out. There's a lot packed into that one sentence, Gary, easily opt out, but you got to make it super simple. It's got to be easy to find, and you got to find a way to do it. So that's number 2. And that has to interact with the automated marketing. It can't just be like, the stuff that goes on in your back-end systems. It has to control that stuff that happens automatically. And third, you have to strongly consider, and some view it mandatory, that not only do you have to take it in a mandatory, sort of like a manual way, but you have to set up the infrastructure to take it in a touchless way, including via that global privacy control concept. So those are 3 critical support elements that you have to have in place. And if you're thinking about infrastructure, as we talked about it, that is not a cookie tool. I'll just be as simple as that. So cookie tools really sit usually in the browser, and they were built to, get permission and to drop cookies. That's what they were meant for. And here you're talking about a different kind of exercise, as Michael, Gary, and I have talked about, that's about not only governing what happens in that browser area where your cookie tool used to live, but the automated marketing side. And then Gary, we've talked about this, the marketing that the marketing team does outside of that automated marketing. There's so many broadly used platforms like Adobe and Marketo and Eloqua and Dynamics and HubSpot, that if your team is using them, you have to make sure that the front end and back end are communicating so you can actually treat that opt-out. And then finally, as Michael covered, you have to have the infrastructure to not only understand it and govern it internally, you have to start thinking about how you're going to signal through your networks. And I think IAB's framework is a really, really important thing to look at in that concept. Sheridan, the other thing that I like to do when I'm thinking about technology, and more in the US, the marketing community is going to have to own this issue. It just is. And for those of us who have been operating around the world for the last couple of years, if you go to almost any other jurisdiction, and certainly in Europe, when a marketing team's about to run a marketing campaign, privacy and GDPR compliance is usually like number 1 or 2 on the list. Gary, I suspect you're nodding, right? It's just a part of the culture. And the entire marketing world, and the three of us have even spoken at basically marketing activation kind of communities, it's waking up to this. And there's going to be a pretty major sea change in terms of this becoming just a thing that every marketer looks at critically. And so one thing I thought would be helpful is to cover the 3 critical questions, in my view, that might help right now when a marketing person is talking to a privacy or a member of our privacy community. So I'm going to propose these real quick. I'll put them up on the screen as well. And the reason I highlight these is my experience from the privacy side is that when you're talking to a marketing professional, if you just ask the question, are you selling personal data? Are you selling our data? Most marketers are going to say, no, we're not selling data, or unless they know it or it's part of your business plan. And so 3 critical questions I would start to ask that tie into what Michael, Gary, and I have been talking about are these as a nomination. The first is being a little bit more specific. Are you or are we, using any scripts, tags, or pixels to improve our social media ads? It's general enough, you'll have your own language, but the whole point is try to ask some questions that make you understand how data is interacting with social media ads, and try to get a sense in the marketing sort of language of what they're doing to improve how the ads are shown. Although we haven't covered this, and I'm sure, Michael, you're going to cover this, but it's clear to me that the states looking at regulating digital marketing are not going to stop by saying only the data sharing for purposes of first showing the ad that's it in terms of a sale of data. I believe that other normally used marketing techniques like measuring performance, like how is the ad actually performing? It shares many of the widely used techniques that, just for the privacy community's sake, that your marketing teams are using to measure how the ads are actually performing. They share the same kind of data often to do that. And so asking a question, how do you actually measure the performance of your ads, might enable you to have a conversation with your marketing team on whether data is being shared, such that you have to think about this. And a third one that's come up a fair amount that's in the same vein is this concept of how are you capping, it's called frequency capping. How are you capping how often somebody sees an ad? This is in the same vein as like performance, but again, often the same kind of personal data is shown. And so again, I'm thinking about some ads, some questions that when you're engaging with your marketing team can move away from you asking the more charged question, like, are you selling data? And starting a broader question and a conversation with your marketing team in a collaborative way that allows you to say, did you know that some of these things, even though they don't really fit into what we would think of as a sale of data, it's what some of the regulators are starting to call a sale of data. You ought to be aware of it. And we need to start putting the right technology and notices in place so that you can actually do this the way you want. And so, Sheridan, from my side, those are some of the leading edge questions that I would come to. And it allows the privacy team and the marketing team to start collaborating on how do we put the right things in place, because there are really good technical solutions that we can cover that allow you to do the 3 things I just talked about, which is wrap the automated marketing, give a really good manual choice, and start giving a touchless way to opt out of these.
Justin, if I could jump on that 3 list, and if you wouldn't mind bringing that back up, that would be great. So one of the things that I hear from marketers and that I talk with them about is the sea change that we're beginning to see about what their obligations are. The historical model in the United States is for large marketers to say, hello to my agency, this is your responsibility. Make sure everything complies with the law and indemnify me if something goes wrong. And suddenly we see changes in the law and in the rules that become stressors on that approach, and that you need to see some more fundamental change. And they're beginning to see that. So if you look at the requirements around auditing service providers that you need to have in your contracts, that's one indicator of it. I think a huge sea change in the draft rules is language that talks about in order to not have legal responsibility for the wrongdoing of your partners, you need to do diligence of them. Well, that's not something historically that marketers have done, which brings us back then to this list, right? Like now suddenly there could be sales of personal information that marketers are either engaging in or causing others to engage in that have certain legal obligations, and they need to get their arms around it. So maybe if we just take a minute or two and talk about why some of these issues really amplify the Sephora concern about the breadth of sales. So we talk about the use of scripts, tags, or pixels on a publisher or advertiser's page. Sometimes that could be used for social media purposes. It also can be used for things that are identified in question B to measure the performance of the ad. Well, let's dive in and talk about that in the most practical sense possible. An advertiser only wants to pay for an ad if an ad can be measured. And how does a data flow happen to measure an ad? Well, if I go to a publisher site as a consumer and an ad is rendered, there's a pixel in that ad. And it sees that I've clicked on this ad, that I saw the ad, and sends that personal information to potentially the advertiser's DSP, to the measurement company that was hired by the advertiser or the advertiser's agency. And then I go over to the advertiser side after I click in the ad. And then maybe I add something to the cart, or I abandon the cart. And that information is sent over now to the measurement company. One of the things we heard from the executive director of the CPPA at one of the pre-rulemaking meetings was that he viewed measurement as a sale. And so now, if you're in California, you need to have contracts in place to ensure that these sales have contracts, even when there's no opt-out. And if you have service provider agreements that are in place, which oftentimes marketers do with respect to their measurement company, that service provider under CPRA can't combine the information that was received from the publisher, which is one of the things that we're trying to solve for and create a solution in the multi-state provider agreement that allows publishers and advertisers to jointly designate the measurement company as their service provider. So, and frequency capping is another one of those things. So if you think about me as a consumer, I go to 5 different publisher websites, and I've seen the same ad 5 times, I might have hit the cap that the marketer set for their demand side platform as the maximum number of times they want the consumer to see and for which they'll pay for an ad. Well, that requires sending the information about me that I saw the ad from those 5 different publisher sites to the DSP, which is now a sale of personal information. Well, that raises a problem, I think, right? Because if it's a sale of personal information, but DSPs don't enter into contracts with publishers, they enter into contracts with advertisers. And so again, this is one of those solution sets that we're trying to provide for the MSPA to fill in those gaps. And just to then put my own wrapper and contextualize this, Sephora comes on top of this, 2-year learning exercise we've had, which is the regulator really does mean sale is broad. It means that when there's a pixel or SDK or other technology that's used on the page and personal information is disclosed, that there is going to be a sale of personal information. Now, certainly we saw that the benefit conferred in Sephora, at least in some cases, we don't know all the pixels that were used, but there might be an analytics dashboard or whatever received. Okay, but now we got to think about the harder questions that come from this. Well, what if there's no analytics dashboard? Is there still a benefit conferred? To me, every time everyone looks for a little rabbit hole to say, oh, there's still a crack in there, I can say it's not a sale of personal information. I continue to think that is a mistake, because I think the regulator is going to say, why would you put the pixel on the page unless you got some benefit? I don't care that you didn't get a dashboard, but you still got some benefit out of it. And that's going to be a sale. And so for those who are still in a place where they're focused on esoteric rabbit holes to try to create these intellectual zones of protection, they're going to continue to get blown away as they have for the past 2 years. So our viewpoint as the industry association is, you certainly may take those positions, but it's certainly probably better off to just, assume that that's where they're going to go and just, prepare accordingly. And that's what we try to do with our industry approach. So hopefully that helps.
That's fantastic.
Have you thought, by the way, of making that IAB's little catchphrase? IAB, we're against esoteric rabbit holes. I mean, that might be a nice catchphrase you could take to the marketing team. We are against a big no esoteric rabbit holes. It's like a catchy phrase for IAB.
Oh yeah, I can see all the memes coming on Twitter.
If I could jump in, I mean, Michael, his explanation was perfect. And he mentioned the one word that is really driving a lot of this and causing so much consternation. It's because CPRA revises the definition of a service provider by saying that a service provider cannot combine the personal information that it collects amongst multiple businesses or that it collects on its own. It's that word combining that is driving all of this. Because in Michael's example of measurement and analytics and frequency capping, that service provider needs to combine information from different businesses in order to generate their reports. And now with this prohibition on combining, it is pushing, it's making the service provider lane much narrower. And service providers cannot do as much as they could under CCPA. So that's why the IAB solution in the multi-state privacy agreement, something of that nature, is very helpful, because it's, as we sit here today, lots of companies like to say, oh, I'm just a service provider. It's not a sale of personal information. But that's going to be harder to say in 2023 with this combining prohibition. And then the second thing I wanted to hop in, what Justin said earlier about giving tools and making things easier for consumers. When the latest draft of the CPRA regulations came out last week, I think in some respects they were helpful, and in some respects they made things more challenging for businesses. They were helpful in the fact that they took out some things that were very, very challenging, but said, we're not going to address this at this time, leaving the door open for the future. For instance, there was language in there about complying with opt-outs on CTV platforms, connected TVs, smart TVs, and other internet-enabled devices. And they removed that language and just said, we're not going to address this at this time, which was nice because they realized it's very challenging. On the other hand, they repeatedly used language such as reasonable expectations of consumers and symmetry and choice, and doubling down on the fact that it's got to be just as easy for a consumer to get out of your marketing funnel as it was for them to get in. And so how can you do this? You need to have tools that make it possible for consumers to easily get out in some seamless way. They talk about, on the GPC signal side, doing things in a frictionless manner, which is actually a specific standard in the regulations. So there need to be ways to do this easily. Another buzzword that is thrown into the new CPRA law and the regulations is dark patterns. You may have heard this come up many times. The Federal Trade Commission talks about dark patterns all the time, and dark patterns are practices that frustrate the consumer or obscure the ability to exercise certain choices. And this will now be illegal to have a dark pattern. So again, it's really got to be that easy in and easy out. And that's a challenge because your marketing people don't want to give people the easy out. They want to get them to come into the marketing funnel, but they don't want to lose them as easily. So it's a real challenge between your legal teams and your marketing teams and your tech teams coming up with the appropriate process to allow people to seamlessly exercise their rights.
Yeah, and if I may, on Sheridan, just briefly to follow up, and I'm also going to start with some of the questions that are coming in from our audience, if you don't mind. Pick up on both Michael and Gary's points. Not only are there guidelines that are in the regs that are important for folks to read, but I think a concrete view of what it means in the user experience would be important for folks to see. And if you haven't seen it, we have demos you can see on our website of different choices you can make, or you can request, obviously, to talk to Sheridan and others on our team. But I'll give you an example, Gary, of interesting, complex issues that are going to be what, Gary, you and Michael and others decide. An example of what is a dark pattern are things like, when do you show the notification, and how do you show the notification of how the person can go and record the opt-out? And on one hand, I think we've all agreed a do not sell link at the bottom of the page makes a ton of sense. So let's assume that's there. But now when you get to the point, and again, if you see it, it really becomes concrete to me. And Gary, I know you, me, and Michael have looked at these kinds of examples, but now you're interacting an opportunity in a user experience between somebody hitting a button and interacting with something, another channel or opportunity that's touchless. And I know it seems like it's not that hard, but it's actually kind of hard when you look at the patterns, because you get to start like, which is the flow and how do you respect it and what do you show on the page? So even if you have a do not sell link, as an example, if you go and see some of these examples we have, do you show that you're taking a global privacy control? Is there some visual indicator that you've taken it? If so, where do you show that? These are the kinds of like interesting choices. I don't know that it's going to be into the category of a dark pattern, Gary, but it does become a little complex. If we take a choice via dark pattern, our product actually interacts with the manual choice. So you can say, okay, here's what I chose. That's an interesting user experience thing, especially when you look at some of the broader guidelines, Gary and Michael, in like, when do you take what? And then, I mean, it caught my eye, Gary, for example, that if you opt in after you opted out, the draft regs have some specific guidelines, like proposing that you give a second like warning. Are you really sure that you want to opt in? You previously opted out, something like that. That's an interesting perspective from California, especially because we all know that the great movement right now is against pop-ups or like something interrupting your visual experience or making you stay in the experience longer. You know what I mean? And so if you've come and you've opted out, then you via GPC, and then you want to accept some communications, having somebody go through and then really, really confirm that they do it can be kind of annoying. So I think there's going to be some interesting technological issues that come up in the user experience. I personally am a little bit worried, and I don't think I'm the only one, that in the first rollout of these new laws, And certainly after CPRA comes out and you have like 15, 20 new choices, Gary and Michael, I'm really worried that if we don't have a good user experience for consumers, that they're gonna like get turned off on the whole thing. You know, like, why do I want to see a pop-up with like 40 different choices that I can't understand? I've showed, you know, a bunch of folks this concept of an opt-out of cross-contextual behavioral advertising, like probably all three of us have. And most people I know outside of the community that's on this call, they laugh out loud and say something like, this is the most ridiculous thing I've ever seen in my life. Like, who the heck knows what a cross-contextual behavioral ad is, or you know what I mean? It's just not a commonly understood issue. And to explain what it is, it takes like a paragraph of text and some explanation. It's not like you can just say 5 additional words. So I don't know, I'm a bit worried about it. I'm worried about it just from both the company side and the consumer side, because I think there's some hard technological user experience kind of issues that I think it's going to interrupt people's experiences, and I'm worried it's going to make people just hate the whole thing. I don't know. Do you have any reaction before we go to the question, the couple of questions?
Yeah, I mean, and the things we're seeing out of the California regs, it's very subjective, you know, in terms of what's the reasonable expectation of the consumer. So what is going to be the experience that's going to your point, Justin, not frustrate the consumer, but also comply with the law. And I think it's very challenging to put that together. I mean, I think there's going to be a lot of space in that, you know, esoteric intellectual rabbit hole that Michael's digging for all of us, because there are so many areas here where you could argue one way or the other what should work. You know, one little fun nugget: we're all talking about these global privacy controls and everyone must comply with them, especially under CPRA next year. Well, what are they? And it's interesting the way it was defined in the CPRA draft regulations. They say the signal should be in a format commonly used and recognized by businesses. I would argue today there is no such thing. There is no common recognition of these signals by businesses. So I think it's going to be, you know, Justin, to your point, a real challenge for businesses to come up with a consumer experience that doesn't frustrate the consumer, doesn't cause you to lose all of your customers, but at the same time complies with applicable laws. Takes a lot of work.
Well, do you mind if I put one question, or we'll probably only have time for one or two? I'm glad folks are actually engaged and on the question side. Do you mind if I throw one out to both of you real quick?
Sure thing.
There was one question that came in that's very specific, which is important. Do companies need a do not sell link now and then a do not sell /share link on 1/23/23 or 2023? Or like, how do you think about do not sell versus do not sell and share? Do you have like one or two? Is it one combined version? Any reaction to that?
You know, maybe what I'll do is I think I'll articulate the debate that that is ongoing in the digital ad community, and maybe, you know, Gary wants to talk about, you know, the actual links themselves. But there is a debate right now about what is legally required as of January 1st versus July 1st. Mm-hmm. And there is some ambiguity in the statute in that regard. And so, you know, the CPPA's enforcement powers begin on July 1st. Although the AG's office still has enforcement powers now. There are some who look at that ambiguity and say, well, you know, I should make sure that I've got it all tidied up by July 1st rather than January 1st. Of course, there's always going to be a counter response. Why would they make a January 1st effective date for the law if they didn't want there to actually be major requirements? So it's like a classic case of some statutory ambiguity that exists in the statute. I tend to take a conservative approach and say, I look at ambiguity and I say, I'm going to comply with January 1st. Now, I also recognize at the same time that there are a number of companies that are challenged with that January 1st deadline. Actually, I'm hard pressed to know one that is not challenged by that deadline. If I were in your shoes, I would probably look for substantial compliance. So getting to the question of do not sell and share, yeah, I'd have that up on my site January 1st as part of that substantial compliance effort. Gary, what are your thoughts?
Yeah, I mean, we could spend another hour instead of the 120 seconds we have left talking about this complex language in the law about this July 1st date, because it implies that they cannot enforce and doesn't take effect until July, but at the same point says that all the prior CCPA provisions as amended by CPRA are in effect during that 6 months gap period. So to Michael's point, I would get compliance moving. Look, regulators are sometimes reasonable and they understand that things are not perfect. So, you know, if you can show that you are making efforts and you are getting close to compliance, that's much better than if you got a letter from the AG or the new California Privacy Protection Agency and you just shrugged your shoulders and said, I haven't done anything yet. You really got to show and document that you are making efforts.
If I may, I'll add one last thing, and it builds onto a bunch of the questions. And I will also forward, I think if our team will forward the questions around to the panel, and if there's a way for us to communicate back some of these, we're happy to do it. I know Gary and Michael do this all the time. But a question we're getting all the time, and our product's built for this, but it's a little counterintuitive, is what the heck what does it mean? And how do you collect a consent if you're not getting somebody to give you their email address or log in? Because it's not actually intuitive. And the way we built our platform is for synchronicity. So the way I think about it, and Gary and Michael, maybe you can give me your perspective, is when the enforcement teams or regulators are looking to tell you whether you did the right thing, if your brand is able to take certain, what I'll call probabilistic identifiers, like IP address or other things like that, where somebody hasn't logged in, and they're able to use that information and effectively kind of re-identify somebody and then serve an ad to them, then when you're collecting the opt-out, you have to collect the same information and be able to affect the opt-out synchronously to the same extent you were able to advertise to them. That's the way I think about it. So you have to be able to collect it using, like, if for marketing purposes, you're collecting IP address and a bunch of other things, and then you use it to serve an ad, you have to collect that same stuff when you're collecting an opt-out, because otherwise the regulator is going to say, you can't really advertise to them and then not opt them out of the same kind of framework. That's the way I see it. So it is a little bit different than like some of the log an email address and put it in. There's some ways that you have to actually synchronize your marketing and opt-out programs, and we'd be happy to talk to you about it if it's helpful for your particular business. Sheridan, I know we're out of time. We've gone over. It's great to see there's questions, and I'll just say thank you to Michael and Gary for joining us and all of our viewers before I turn it back over to Sheridan.
Yes, thank you both Michael and Gary and Justin for being here this morning. And this has been great content. For all the questions that were asked, we will do our absolute best to try and get an answer back to you. We'll take those questions offline. We'll get answers for you and we'll circulate them later. Thank you so much to everyone for attending. We really appreciated it. It's great to have everyone here and have this discussion. If you do have additional questions or want some more information, please feel free to reach out. I think anyone here on this panel would be happy to discuss with you. And certainly here at WireWheel, we will make time if companies are, needing questions answered around CPRA or the change of sale. And we hope everyone has a wonderful rest of their day.